Imagine a constitutional provision that consists of just 6 words. Yet, today, it protects your privacy, your health, your education, your livelihood, and even your right to breathe clean air. This provision is Article 21 of the Indian Constitution. But here's the interesting part. Article 21 was not always this powerful. In fact, when the Constitution came into force in 1950, its scope was much narrower. Over the decades, through a series of landmark judgments, the Supreme Court transformed Article 21 into the very foundation of human dignity in India. Today, let's understand this remarkable journey. Hello everyone, my name is Rajni Jha. Welcome to Drishti IAS. So as I told you, in today's session, we will talk about Article 21 and its journey from life to human dignity. Let's get started. First, let's see what exactly Article 21 says. It says, no person shall be deprived of his life or personal liberty except according to procedure established by law. Here, there are few words and phrases that are extremely important, which are no person, life, personal liberty, and procedure established by law. No person means that this is available not only to Indian citizens, but also to foreigners. So this is available to all persons, not just citizens. Life means to have a dignified life, not just protection against unlawful killing, but to have dignified life. Personal liberty means there should not be any interference, arbitrary interference by state. And we will talk about procedure established by law in a while. So Article 21 is a fundamental right and it is there in part 3rd of the Constitution. We talked about life. Life means not just survival, not just human existence, but to have a dignified life, to have a life with dignity. And it includes right to livelihood, right to health, right to education, shelter, privacy, clean environment, and many more rights that we will see ahead. So this here, life does not mean that you should be just existing. It means that you should have a dignified life. As far as personal liberty is concerned, it means freedom from arbitrary interference by the state, as I told you. What does that mean? That you should have freedom of movement, freedom to make personal choices. There should not be any arbitrary arrest by the government or the state, and the freedom to live with dignity, right? The next part here is the procedure established by law in that definition. Now see, to understand this, we need to go back to Constituent Assembly. There were two options for our constituent framers, and they were procedure established by law, and the second was due process of law, which is also there in American Constitution. Now, what is the difference? In procedure established by law, the court only examines whether or not a law exists, and second, whether the procedure was followed or not. It does not really care about whether the procedure was fair or just or reasonable, whether the law was reasonable or not. It does not care about that. Procedure established by law only cares about whether there is a law that exists, and second, whether the procedure is followed or not. In due process of law, on the other hand, court examines first whether a law exists, second, whether that law itself is fair, just and reasonable, and third, whether the procedure has been followed properly. So the framers actually preferred this one. Why? They preferred that one so that the law, judiciary does not become too powerful, unnecessarily powerful according to them, because it will then create conflict between judiciary and legislature. So to curb the excessive power so that the judiciary does not have the excessive power, they went for procedure established by law. Now, over the years, there have been two different interpretations of it. The early interpretation was in A.K. Gopalan case, where A.K. Gopalan was arrested under preventive detention laws, and he said that his fundamental right is being violated. Now, the court took the earlier interpretation, which was a narrower interpretation. In this case, the court said, as long as there is a law that authorizes detention, and we have preventive detention laws, so as long as a law exists, Article 21 is satisfied. Fundamental rights, because in this case it was said that his fundamental rights were violated. The court said fundamental rights are operated differently or separately. They are not a part of this. And third, the judiciary would not examine whether the law was fair or not, whether the procedure was fair or not. It only needs to understand whether there is a law that exists and whether the procedure is followed. Whether or not the law was fair and just is not the concern of Supreme Court or judiciary. That's what it said. So it gave state considerable power. But there was a turn of events in Maneka Gandhi case. The next turning point was Maneka Gandhi case, where Maneka Gandhi's passport was impounded, it was taken away, and there was no reason given. There was no logical reason given to it. It was said that it is not in public interest to give you a reason. So there was no adequate reason provided and the passport was taken away. Then the Supreme Court, of course, Maneka Gandhi went to Supreme Court, and Supreme Court then asked, can the state restrict liberty through an unfair law? Can the state simply restrict somebody's freedom and liberty by just because there is a law that exists? Does that law have to be fair or not? And the answer was, of course, the law has to be fair. The Supreme Court adopted a wider interpretation in this case and said that procedure established by law must be fair, just and reasonable. Up until now, what was happening? Up until now, the judiciary was saying if a procedure is followed, that is enough. Now the judiciary is saying the procedure has to be fair, law and reasonable, fair, just and reasonable, right? It says that arbitrary laws violate Article 21 and fundamental rights are interconnected with all of these. So up until now, there was only one stance that was taken, which was if the procedure is followed and a law exists, that is enough. But now the Supreme Court took a wider stance and said that A, law has to exist, B, procedure has to be fair, just and reasonable. And see, understand here, it also means that the law has to be fair. If there is a law, the law has to be fair, the procedure has to be fair and just, and the law has to exist. So this is looking more like due process of law, isn't it? So the phrase was not changed, but the interpretation became more like due process of law. This is something you should understand. Now, as I told you here, the Supreme Court said that fundamental rights are interconnected. So the Supreme Court said that Article 14, 19 and 21, they are interconnected, and that is called the golden triangle of fundamental rights. How? Let's say in any case, any law that concerns itself with liberty, all these three things will be checked. How? In Article 14 says equality before law. So it will be checked whether the law is arbitrary or not. Is the law arbitrary? Does it treat people unequally? If it does, then it will not be valid. So Article 14 will be checked first. Then Article 19, does it unnecessarily restrict freedoms? If it does, then again it will not be valid. If it does not, then it will be valid. So this is the second test. And third test is Article 21. In Article 21, we saw due process, procedure established by law. So here it will check whether the procedure is followed properly and the procedure is fair, just and reasonable or not. If all these three tests are confirmed, then only any law concerning liberty will be allowed. Otherwise, it will be unconstitutional and void. And this is called the golden triangle of fundamental rights. Now, apart from this, there were many important judgments. We have taken just two of the most important judgments, which is first is Unni Krishnan case 1993, in which Supreme Court said that education is also a part of Article 21. It has to be a part of Article 21. So it inserted Article 21A, in which free and compulsory education is given for children aged 6 to 14 years. And the second important case is Puttaswamy case 2017, where right to privacy became a fundamental right under Article 21. The Supreme Court said that privacy towards one's body, that is bodily autonomy, personal choice, data privacy, informational privacy, all of these are also under Article 21. So just like this, through several judgments, Article 21 and its scope kept on widening. And now it includes so many different rights under one composite right, which is Article 21. So after 1978, Article 21 expanded dramatically. Right now we have a lot of rights under this. For example, rights related to dignity, right to live with dignity, right to reputation, right against torture, or socio-economic rights like right to livelihood, right to health, right to shelter, right to food. But see, one thing you should notice here is for socio-economic rights, we can say that everybody has right to livelihood, health, shelter and food, and maybe government should work towards it, but we should also have resources for it. If we don't have enough resources for it, we cannot enforce it, right? In any case, next is environmental rights. So right to clean air, clean water, pollution-free environment, these are also under Article 21. Or right to legal aid, speedy trial, prisoners, that is rights related to justice is also under this. So there were a lot of different rights which were included under Article 21. The scope of Article 21 kept on widening through different verdicts and different landmark judgments. Now the last part of this analysis is the critical analysis. What exactly are the strengths and weaknesses? Are there any weaknesses? Are there any criticisms of Article 21? So yes, there are. Strengths, I'm sure you must have already guessed. First, it protects citizens from arbitrary state actions. It keeps changing constitutional values according to the society. So it adapts constitutional values to changing realities and changing society. It strengthens democracy, human dignity, and it supports social justice. It supports welfare of people. But at the same time, there were some criticisms also. What were the criticisms? The scholars kept saying that the courts have expanded Article 21 a little too much. So it is too broad now. Second, judicial activism may sometimes interfere with policy making. See, judicial activism simply means that judges, the courts, come in between and they make sure that whatever law is there, whatever policy is there is constitutional. So they are saying that because of this judicial activism, now it is interfering with policy making as well. And finally, the court says, like I told you earlier, that you can give socio-economic rights, but you cannot always guarantee them because resources are required. Public resources are required for this. Now we have 2 prelims practice questions for you, and I really hope that you answer these questions in the comment section below. Let's talk about the first question. It says, consider the following statements regarding Article 21. First, it is available only to Indian citizens. Second, the right to privacy is protected under Article 21. And third, Article 21 uses the phrase due process of law. You have to tell me which of these is correct, or are correct. Option number A is 2 only, B is 1 and 2 only, C is 2 and 3 only, and D is 1, 2 and 3 only. The next question is, consider the following statements. The previous question was extremely easy. I really hope that all of you give the right answer to that. The next question is, consider the following statements regarding the interpretation of Article 21 by Supreme Court. First, in the A.K. Gopalan case, the Supreme Court held that Article 21 is satisfied as long as there is a law enacted by Parliament. Second, the Maneka Gandhi judgment held the procedure established by law must be fair, just and reasonable. And third, Maneka Gandhi judgment established that fundamental rights under Article 14, 19 and 21 are interconnected. You have to tell me which of these is correct. So that's it for today's session. I really hope that you've understood everything I was trying to explain and you enjoyed the lecture. Until next time, take care.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.